This is the Global Podcast Network, where executives and professionals connect, share, and inspire. Stay tuned for the conversations that drive success.
And welcome back, everybody. I love this feeling. I'm sure you have it too. When you know you have a professional in your corner, like we always say, yeah, I got somebody for you. I've got somebody for you when it comes to estate planning and everything involved in that. And she has provided so much information along the way. I love how we can just throw things to her, scenario situations, because every family is different. Every scenario is different. And she's got the answer when it comes to planning your will, planning your estate. She joins us from Maryland. She is Julie Schejbal on the program once again. How you doing?
I'm great, Steve. How about yourself?
Very well, very well. We have a lot to talk about, and we touched upon this last time we got together. Didn't go into depth, so we're going to put the microscope on executors of a will or people that oversee the situation. Where do we start with that?
So I think start with well, when we think about it in estate planning, the global term is fiduciary, and that just means somebody who acts on your behalf. So that can include executor, or in Maryland, we call executors personal representatives. It can be your trustee. It can be an agent acting under power of attorney. So there's a lot of different titles that fit under that kind of hat. But
are they all essentially the same, though? Just so you know, because I thank you for fiduciary. Haven't heard that one in a long time. Yeah. A lot of people hear it and like, oh, I'm really not sure what that is. Executor is sort of self-explanatory because you execute the plan. But right. Are they very similar, or they're radically different and we don't see that?
I think they're very similar. It's more a matter of timing than different duties. So under your power of attorney, your agent acts while you're alive. His or her job ends when you die, and that's when the personal representative or executor kicks in. So it's more during your lifetime, they're called an agent. When you die, they're called a personal representative or executor. And then with the trustee, again, very similar things, but their duties may start when you're alive and carry forward to your death. So the trustee kind of bridges both life and afterlife, I suppose.
Gotcha. So how do you make that decision? Who's doing what?
So I think it can sometimes be tough. I think sometimes people make it tougher than it has to be. I mean, I think you start with people that you know are trustworthy. I mean, that's like the key. You start with somebody who's, hopefully you're picking somebody who's trustworthy so you can avoid some of the pitfalls that'll happen later. And also, look at people who assess your children or your siblings or whoever you're going to use, assess them evenly or fairly or with eyes wide open. And, if like, well, one of my kids is, super smart, but, overthinks everything or, can't find their way out of a paper bag. Well, we don't want to use that person. This is not rocket science, but you want somebody who's organized, who can move through. And I think also somebody who's somewhat diplomatic. I mean, we all had siblings or friends or whatever who, your last good nerve, not only they find it and step on it, they stomp it into they obliterate by stomping on it. That's not really the person you want. You want somebody who's a little more even keeled, because some of the problems arise because somebody stomped on that last good nerve, when maybe they've been a little more diplomatic. People don't get their back up or their hair, whatever. The hackles aren't raised, I suppose, using an old school term.
I'm sure you've seen so many different situations, and let's just say it, money changes everything.
Absolutely.
Especially when it's with families. I want to go right to a question that we got because it just seems like it fits here. Rebecca in Miami checks in at instantfeedbacksteve@gmail.com. And she says, I appreciate your conversation. How can families proactively reduce the likelihood of estate litigation, particularly when there are strained sibling relationships or unequal inheritances involved?
So I think it's something maybe you're never going to absolutely cut it out. But there are things you can take. One of the things is, again, let's go back to the executor or a person representative. Let's make sure that person is going to do a good job, that they're trustworthy, that they're reasonably diplomatic, that they're organized. And then as they're doing the job, I think the other thing is, and this sounds very rudimentary, but you'd be surprised how easy this is that will help avoid problems, is pick the hill you're going to die on, I guess. So like some people will come in and they'll say, look, I'm the trustee, I'm the person representative. Do I have to give my siblings a copy of the will or the trust? And I'll say, well, you're not necessarily required right away, but you put your backup, they can go to court and get it. But why are you going to go that route? All that's going to do is breed distrust. If you authorize me, I will give them the document right away. Let's not go make them go to court to get the trust or the will. And then I think as far as unequal distributions, a lot of that really comes into play with, where the parents are in life. Like, if somebody does a deathbed distribution, they're literally in the hospital and they get somebody to sign over all their stuff to Rebecca, that's going to be full-blown litigation. And, that's just a bad look. But if dad or mom did it, 10 years ago when they were still living alone, they were working, whatever that looks like, well, it's going to survive a lot more scrutiny, because then you say that, well, they were less likely to have been influenced or undue influence, or, have been, not in the right mind, whatever that looks like.
How do you prove that? Let's say you find out that a relative has left everything to one party or the other, and you're kind of blown away. You didn't see that coming. Maybe that relative said, and by the way, I'm going to say this. This is coming from an experience that I'm aware of. This is real, where somebody had a sizable estate. Uh-huh. It was believed that all were getting equal share. Mm-hmm. And a couple of family members, after this person had a stroke, were able to get her to sign something that says the lion's share went to them. And that basically cut everybody else out, or reduced by a great degree. And she probably didn't even know what she was signing. She just signed it. It was an irrevocable trust, if I remember correctly.
Gotcha.
What would you do in a situation like that? I mean, that's a lot to prove there, right?
Exactly. The first thing I do is go, well, we need to hire somebody else to litigate, because I don't litigate. But beyond that, I think you start looking at the facts and circumstances. Like, this person had a stroke. What was her doctor's evaluation after the stroke? Did she, come back? Or, because we know people who have strokes who basically can come back, maybe not to, 100%, but they can rebound. So what was that like? Was she dependent on, these people to, do her, totally dependent? Could she, cooking, feeding, medicine?
As I understand it, just to give you the clarity on this situation, sure. They lived states away and now got very much closer to her. She was bedridden. Yeah. I helped her with a couple of things, but there was help in the family. I mean, aides that were, from paid or insurance or whatever. They just saw the opportunity and jumped in. But I would imagine very hard to prove. Very hard to prove.
I think so. But I think facts like that do raise suspicion, because you have somebody health going deteriorating, people coming in from out of state, that's ripe for manipulation. And then it's just a matter of, can you put the medical records, the other evidence together to say, hey, this is, not going to fly. I mean,
there's another thing that I think just comes to mind here, floating out there. If it's not legal, it's karma.
Well, exactly. Yeah. You're kind of hoping there's some karmic justice somewhere, I think. For sure.
But then there's others that believe if it doesn't happen in this lifetime, maybe another. If you believe in that,
right.
What can you tell us about anything that we're missing, haven't talked about when it comes to choosing an executor or a fiduciary in these situations?
I mean, I think we've talked about it. I think we've hit the high points, and
Sure.
it's, just again, making sure that the person you have selected is trustworthy. I think, and I mean, we may have hit this part, I'm not sure, is some clients come in and they go, well, I got to pick Julie because Julie's the oldest. But in all honesty, Steve or Lisa would be better. And to then I always reply, well, you don't have to pick the oldest. You can go outside of birth order, and you want to pick whoever you think is best suited. And because I tell clients all the time, you know, if you pick Julie or Steve, the other kids are going to think, wow, we always knew that mom and
Oh.
dad like Steve better, until they find out how much work Steve has to do. And then they're going to say, well, what did Steve do to make him so angry? So, it's not, it isn't this thing that, you're this badge of like honor, or,
It's a
you're
job.
giving,
You're getting
it's a
basically a
job.
job.
And you have to follow the will. So it's not even, you can say like, oh, I didn't like what mom and dad did. I
Right.
think Steve deserves more. No, you got to follow what's written. So, I mean, I joke all the time in the office, like, about the only thing I think that the executor or personal representative has over their siblings is they get to pick the realtor who's going to list the house or the real estate to sell it. I mean, that's, they're going to got to follow the rules. They got to follow the law. So it's, they can't manipulate things that greatly.
Mm. Something's coming to memory that the executor receives compensation for their work in this.
So
Is
they
that
are
true?
entitled to that. In Maryland, it's roughly 3.6% of the estate. So if you have $1 million estate, it's $36,000. Um, they're entitled. They don't have to take it. It is work. I talk to the clients all the time and say, you're entitled to it. Usually the conversation starts at the very beginning when they come in. We talk about it. They may say, no, I don't want anything. I'm doing this for mom and dad. I want to treat my siblings equally. And then, but when we're ready to wrap it up, we have the conversation again. And many times it's still, no, I did this for my parents. I don't want the money. Other times it's, well, my siblings were so annoying. I'm taking the money. So just
Mm.
this over that arc of time.
In your opinion, the three something percent, is it truly worth it
You
for
mean
the
in
work
terms of,
involved? For the work involved.
I mean, I think, like if you have I mean, it really depends, because if like you had $1 million estate and it's $1 million in cash, well, you're going to get paid a whole lot of money, and it may not be that much heavy lifting. If it's $1 million or more in real estate, then you're going to be doing more heavy lifting, because you're going to be paying bills to make sure the utilities are on,
Ooh.
meeting
Mm.
with the realtor. There's like, depending on what how the estate's configured. And I mean, like, part of it is like, it's how much, how annoying, I guess, the other siblings are. Sometimes they sail
Mm.
through, and you take the commission and you make like out like a bandit. Other times you probably are getting, it's like kind of a negative hourly rate.
Okay, so I'm seeing different things here. You're also a property manager.
Yeah, I mean, you
you
got to make sure that the house, the bills in the house, even if it's
yeah.
just one home, they don't go away.
Yep, you're a
You
personal
know,
assistant, even though the person may not be here, but you're doing
yeah,
those duties.
right.
Okay, uh, so the I guess the short answer is on is it worth it? It really depends
Yeah,
on
exactly.
what's in front of you. Here's another one. Thomas in Chicago says, "How should someone approach estate planning if they own property in multiple states? Does that automatically mean multiple probate proceedings?"
So yes, it does. So when you do probate, it's primarily in the state that you're living in. So he would be going through that in Illinois. But if he owns, a house in Montana and a house in Florida or whatever, he would also have what's called ancillary probate on the real estate. So in that case, I think we've been talking about how when I do revocable trust for people, I don't necessarily say do them to avoid probate. In this case, I would say to Thomas, let's look at a revocable trust. because the assets in the trust, if you put your Montana home and your Florida home and whatever else in the trust, then you're going to avoid the probate in those various states. So that would, that would be I think the document to look at in that instance.
Hmm. I'm going to go right to this question, and my eyes popped out when I saw it
Okay.
because it's one that when you have older parents, one that I believe most of us think of. Sophia checks in instant feedback, steve@gmail.com. She's in San Antonio. She says, I'm concerned about long-term care costs wiping out my parents' savings. What role does Medicaid planning today? I'm sorry, what role does Medicaid planning play in estate strategy? And she also says, P.S., how early should families start thinking about it?
So I think it's a good idea to, so with Medicaid, it's the money comes from the federal government, and the federal government imposes certain regulations, but it's also administered at the state level. So it can be different in Texas and Maryland and everywhere. So, I mean, I think it's a good idea you don't have to plan right now, but if you notice that your parents are getting older, maybe one of them or more of them, one or both are starting to slip, then I think it is a good idea to get in to see an elder law attorney to talk to them about him or her about the cost and what can be done to preserve assets,
Mm,
maybe not for the kids, for the next generation, but there are tools in the law that allow money to be shifted to the spouse who isn't in the nursing home, the healthy spouse. And that's what you kind of want to look at, I think, because you don't want dad to go in a nursing home and mom to be home and be relatively healthy. And, you're worried that mom's eating oatmeal 3 meals a day because she can't afford anything more. Um,
mm.
because to qualify for Medicaid, you got to be broke. That's what I tell clients. And broke means less than $2,500 in your own name. So it's
Mm.
very,
I've often heard this that there's a certain number of years that Medicaid can go back. Is that still true?
yes, it's five. Right now, it's 5 years.
Five
And what
years.
they're
And
looking for is gifts. So when I talk to clients, and we can delve into this more in another session because it's a lot of moving parts, but
ooh,
I always tell clients when they come in you got to be broke. And my niece and nephew, who are 20 and are really, pretty smart kids, know nothing about Medicaid, could have you become broke. And that would be by dad goes in a nursing home and you just pay the cost of the nursing home out of dad's money, and he will run out of money because the cost of care is, I would say anywhere from it varies from state to state, but probably $10,000 to $15,000 a month. So unless mom and dad are sitting on a huge, huge amount of money, you're going broke pretty fast. So, and the key with Medicaid planning is to try not to go broke. If you're going broke, go broke in an orderly fashion, I think, in a fashion that's as helpful to the surviving spouse, the community or well spouse as possible.
strategic broke.
Exactly. That's a good way to put it. Yes.
What if you want to leave some of your estate to a charity? How do you? Let's talk about charitable planning.
So there's a couple of ways to do it. The most basic, straightforward way is to say, when you're looking at your will or your trust or whatever, and you say, all right, I would like to, in addition to my family, leave something to my church or my synagogue or my alma mater or the Girl Scouts or I don't know, cancer, whatever it looks like. And you can do it several ways. You can do it, the most straightforward way is to say, I leave $10,000 to the University of Maryland or to Duke or whatever. Or
Hmm.
you can say, sometimes people will say, I leave a percentage. I leave 10% of my estate to these different charities, and then the remaining 90% would be distributed among the children. And those are the most simple, straightforward ways to do it. What you don't want to do, have clients come in and they go, well, I'd like to leave some, but what I'm going to do is I'm going to leave it up to my executor or personal representative to make this gift when I die. And you can't do that because, you know, your will's going to say divide everything between Julie and Steve, and then Steve, as personal representative, says, "Well, I know that she wanted $100,000 to go to her the charity or whatever," and Julie's going to say, "Well, dude, it's not in the document. You can't do that. You got to follow the will." So you sort of have to, make arrangements in the document itself.
One thing just popped in my head here. What happens when you designate a beneficiary, like on a retirement account, and there's a conflict with the instructions in a will or a trust? Which document actually has control?
So when you have an IRA or a 401k or life insurance, the beneficiary designation controls. So your IRA could say equally between Steve and Julie, and your will says send it to the 50-50 between the University of Maryland and Duke. And then so Duke or the University of Maryland get nothing from your IRA. Steve and Julie, in that case, are the big winners.
So let's say, what's that? I'm trying to think of it. TOD, terms on death.
Transfer on death.
Transfer on death. Okay. So, and a lot of times that's on retirement accounts, 401ks and such. So if you have that, let's say you list your children. Let's say you're getting divorced, and all of a sudden you find out you're getting divorced. Immediately you put the TOD on it's a retirement account, the 401k.
Right.
You should be fine. Even if you didn't have a will or trust, you should be fine with that.
Right. Pretty much. Yes. You would be good.
I don't know if, we don't, you don't have all the cards in front of you, but I'm just saying that.
Right. No, it would be a good approach. I guess, like, if you were in the middle of the divorce, what would be happening with the divorce law? I don't know, but yes, you would be good, updating your TOD to, reflect the getting ready, or your beneficiary designation, get rid of the spouse and put the kids or your friends or whoever's going to be the ultimate beneficiary.
So another one popped in. We have like 40 seconds here. Cryptocurrency, digital assets, things like that. How are they handled with estate plans?
Well, you would handle it with the plan, that way. But I think the bigger thing is, and we're just sort of starting to see crypto come in, and is making sure that your information about crypto is somewhere that your personal representative or people who are going to come behind you when you die know how to access it.
Right.
We're dealing right now with our first crypto case, and this guy died, and he was in his 40s. His parents are left. He didn't have a will, and his parents are like very nice people, very not tech. And we're trying to figure out, he left no instructions about any of his assets, much less the crypto. So we're trying to figure out how to crack that case, I guess.
Oh my gosh. Yeah. And you're doing cryptocurrency for security in a lot of regards, but at the same time, it's not like going to your local bank or court, where it's a lot easier. Interesting.
Exactly.
I don't know why that popped in my head, and here you are dealing with it. Julie, I love all the details, your insight, the deep dive that we can do here. You work with people in Maryland. I'm sure on a consultation level, you can answer questions as well. Right. What's the best way to find you?
So they can get me, best way is through my website, which is www.jasestatelaw.com.
Beautiful. I appreciate everything. And by the way, instant feedback, steve@gmail.com. If you have a question for Julie next time we get together, we would love to hear it. Thank you for being here today.
Perfect. Thank you. You have a wonderful afternoon.
You too.
This is the Global Podcast Network, where executives and professionals connect, share, and inspire. Stay tuned for the conversations that drive success.